Special Needs Trust Basics. Hi, I'm attorney Paul Bernstein of the Bernstein Law Group, and in today's video we're going to go through the three main vehicles that people use when there's a disabled beneficiary that could be receiving certain needs-based government benefits like SSI and Medicaid, which have a financial component. If that disabled child owns too much in the way of money, they won't qualify. So there's a variety of ways to get them qualified and not use or lose those funds. So the three main types that we'll talk about today are a D4a trust, also often known as a first-party trust. Some people call it a payback trust. We'll explain why in just a few minutes. A third-party special needs trust, and then an ABLE account. So let's go through the differences. So who can be the beneficiary of each type of vehicle? For the D4a, and let me step back first, why would we use one? What are the situation? What's the issue? With the D4a and the ABLE account, the person that has the resources, the funds, would be the disabled child, possibly. Certainly with the D4a trust, possibly with the ABLE account. So they have too much. We have a disabled child that has too much in the way of resources. They might have bank accounts that have grown over the years. They might be maturing out and now to a level between that 18 and 22 years of age where they now qualify for certain benefits, SSI possibly, Medicaid possibly, and yet they had been receiving gifts that have just been put in bank accounts. They might have been working and setting aside some money, and they have too much in the way of resources. Well, that's where we would use a D4a or possibly an ABLE account. Third-party trust usually comes about because others want to give, typically through an inheritance, but could be outright gifts as well, to the disabled child, but are concerned that if they do give an inheritance to that child from the government benefit side, that would disqualify them from receiving the government benefits, so they'd have to use up that inheritance before they could get the government benefits. So in that concern, we'd look at a third-party trust. ABLE account can be on either side, as we'll show you in just a few minutes. Who can be the beneficiary of each type? Well, for that first-party special needs trust, the D4a, the disabled child can be the sole beneficiary, the only beneficiary of that trust. Now, with the third-party special needs trust created by a parent or a grandparent, what have you, it can be the disabled child, but it can have other beneficiaries if it makes sense in that context. With the ABLE account, it would be solely the disabled child as the beneficiary. Who can create or make the vehicle? So we call it a grantor or a trust maker for the two trusts. The disabled child, if they're competent, can make it, but really it's typically a parent, a grandparent, a conservator, or the probate court in Massachusetts would be the creator. For that third party, it's anyone but the disabled child would create that. And an ABLE account, anyone can create or open up the ABLE account. Who can be in control of that money or those investments, whatever's in the various vehicle? Well, anyone for the first party special needs trust, anyone but the disabled child. For the third party, once again, anyone but the disabled child. For the ABLE account, it can be anyone, including the disabled child, that would be the decision maker on when to withdraw funds and how to use them. How many of each can we create? Well, there's no limit to the number of special needs trusts, whether they're the D4a trust, the first party special needs trust, or the third party special needs trust. I don't know why we would have more than one, but there's no limit to those. However, very important to note, with an ABLE account, you're only allowed to have one ABLE account per disabled child. So a big difference there, only one ABLE account. How much can we put in to each of these? There's no limit on either of the special needs trusts, whether it's the first party or the third party. However, with an ABLE account, only $15,000 can go into that ABLE account per year. So there's a limit. It's not $15,000 per person gifting in there. It's $15,000 total into that one account but can be done every year. And then at death, what happens to any funds that might be left over? With the D4a Trust, the reason they're sometimes called a payback trust is because it has to state that any funds left over go back to reimburse the government for the resources the government paid out for that beneficiary. So it has to be paid first back to the government. If there's any funds left over, the trust dictates where that goes. You can even leave that up to the beneficiary to make that determination. Third-party trust, it's not a payback trust. The government is not mandated to be a beneficiary of that trust for it to be a qualified trust. And it's whoever the trust maker says, or the trust maker may give the beneficiary, depending on their capability to make these decisions. It could even leave it up ultimately to that disabled child to determine where it goes. Typically, the trust will dictate where that inheritance goes. With the ABLE account, very much like the D4a first party trust, it's a reimbursement first to the government, and then if there's any leftover resources, once again, it can be determined where that goes. So a lot of information in a short period of time, but hopefully it's information that helps you clarify some questions or concerns you might have had or confusions regarding these three different vehicles. If you have any other questions, don't hesitate to reach out. Thank you.